Andres bought a suit for the interview 8 months before he was allowed to schedule it. He is an agronomist in Medellin, Colombia, married to Carolina, a U.S. citizen and a school teacher in Orlando. And for years, their marriage has been conducted across airports and time zones. Now, finally, the case is approved. The petition cleared. The priority date is current. All that stands between Andres and the flight to Orlando is a single interview at the United States Embassy and a mountain of documents he does not fully understand. The suit hangs in its garment bag, pressed and waiting, while the paperwork stage drags on and on. If you are watching this, some version of that garment bag is probably in your life too. The hard part feels finished, the petition approved, the wait endured, and yet the finish line keeps receding. Either way, this is for you. You are watching the expert guide from the law offices of Chris M. Ingram. Every week, we take one part of the United States immigration system and make it clear enough to act on. No jargon left unexplained, no fear left unaddressed. Last week, we followed the family petition and the long line. This week is what happens when the line finally reaches your relative abroad. Consular processing, the last stretch that turns an approved case into an actual immigrant visa. And here is the promise. By the end, you will understand exactly how consular processing works, the document stage where families lose the most time, and the single departure decision that can lock a person out for years. A quick note before we go on. This is general educational information, not legal advice for your specific situation. We've put the questions and timestamps on screen so you can jump to what matters most.
Just a quick reminder, if you appreciate this kind of in-depth content, please take a moment to like and subscribe. It helps us bring you more content. Now, on with the video.
Here is the thing to understand first, because it reframes the whole stage. Consular processing is not a second application. It is the final stage of the one you already started, the stage where an approved case abroad becomes a visa in a passport. It is the road taken when the person immigrating is outside the United States. The petition is approved. Then the case moves to a government office called the National Visa Center, which collects the fees, the forms, and the documents before anything reaches the embassy. Once that office is satisfied, the case is sent to the US Embassy in the immigrant's country. An interview is scheduled, and the immigrant attends. If all goes well, the embassy issues an immigrant visa. The person travels to the United States, and they become a permanent resident on entry. That is the whole shape. Approval, the document center, the embassy interview, the visa, the flight, the green card. There is a fork worth naming right at the start because it decides which road a person is even on. If the immigrant is already inside the United States in valid status, they usually adjust status here without leaving the process we have touched on before. If they are abroad, they go through consular processing, same destination, 2 different roads, and which one applies depends on where the person is and whether they can lawfully stay while it runs. For someone outside the country, consular processing is simply the way home. As attorney Chris M. Ingram frames it for the families the firm works with, by the time a case reaches consular processing, a family has usually waited a long time, and the tragedy is watching them lose months more at the finish line to document mistakes that were entirely avoidable. This stage rewards precision. The families who move through it fastest are the ones who treat the document center as seriously as the interview itself.
Now the stage where families lose the most time. And it is not the interview. It is the document center that comes before it. Before an interview is ever scheduled, that office wants a specific, complete set of civil documents and forms, birth records, marriage records, police certificates from the right countries, the immigrant's own application, and one document that trips more families than any other, the Affidavit of Support. The affidavit is a binding promise by the sponsor that they can financially support the immigrant, backed by tax records and proof of income, so the immigrant does not become dependent on public benefits. It sounds simple. It is where cases stall for months. Here is why. The income has to meet a threshold. The tax documents have to be complete and consistent. And if the main sponsor does not earn enough on their own, a second person, a joint sponsor, may have to step in with their own full financial package. Families discover the shortfall late, scramble for a joint sponsor, submit incomplete tax records, and each mistake sends the case back for another round. Every round is weeks. The document center does not chase you. It simply waits, and the case sits still until the file is right. So the discipline is this: assemble the complete civil document set early from every country the rules require, in the exact form requested. Get the financial picture honestly assessed before submitting, so you know from the start whether a joint sponsor is needed, rather than discovering it after a rejection. And treat every requested item as mandatory, because to that office it is. The interview cannot even be scheduled until this stage is clean. This is the quiet middle of the process, where good preparation saves a family more time than anything else they will do.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
Let's answer the questions that are actually keeping you up, in the order you actually ask them. First, what actually happens at the embassy interview? The immigrant attends, usually alone, at the US Embassy in their country. A consular officer reviews the file, confirms the relationship or the basis of the cases is real, checks the documents, and asks about the immigrant's background and history. For a family case, they are confirming the family bond is genuine. The most common problem is not deception. It is an incomplete file or an answer that does not match the paperwork. Preparation means knowing your own case and having every document in order, not rehearsing lines. Second, can my visa be denied at the interview even after everything was approved? Yes, and this is the hard truth of the stage. Approval of the petition is not approval of the visa. At the interview, the officer screens for grounds of inadmissibility, specific reasons in the law a person can be refused. Things like certain past immigration violations, certain criminal history, or an incomplete affidavit of support. Some of these have waivers, forgiveness applications, but not all, and they are complex. If anything in a person's history could raise one of these grounds, that must be identified and addressed with an attorney before the interview, never discovered at the window. Third, why is the affidavit of support such a problem? Because it is a real financial test with exact requirements, and families underestimate it. The sponsor must show income above a set level, prove it with tax records, and if they fall short, find a qualified joint sponsor who can carry the obligation with their own documents. Start this early. Knowing months ahead whether you need a joint sponsor is the difference between a smooth case and one that stalls at the centre for half a year. Fourth, how long does consular processing take? The full stage, from petition approval through the document centre to the interview and the visa, runs a broad range and varies heavily by embassy and by current volumes. The practical takeaway is the same as always. The parts you control, the completeness and accuracy of your documents, are exactly where families either save months or lose them. Fifth, my relative is already in the US but out of status. Should they just leave and do consular processing abroad? Please do not do this without advice. This is the single most dangerous decision in this entire area, and it is the next thing we have to talk about.
Here is the trap that hides at the fork between the two roads, and it can turn a hopeful case into years of separation. It involves a person who is already in the United States, but has been here unlawfully, and who assumes the fix is simply to go home and process the visa at the embassy there. The danger is this: the law attaches a penalty to unlawful presence, and that penalty is triggered by departure. A person who has been unlawfully present in the United States for long enough and then leaves to attend a consular interview can trigger a bar on returning for 3 years or for 10, depending on how long they were here unlawfully. They walk out the door expecting to come back with a visa, and instead the door locks behind them. This is one of the cruelest mechanics in immigration law precisely because it punishes the person for trying to do the right thing the wrong way. There are waivers for this, in specific circumstances, often built around proving extreme hardship to a qualifying U.S. relative. And in some cases, the waiver can be sought before the person departs, so they leave only once the forgiveness is already granted. But this is intricate, high-stakes work, and getting the sequence wrong can cost years. As attorney Chris M. Ingram often puts it, never, ever advise someone with unlawful presence to simply leave and consular process. That single sentence has protected more families than almost any other. If a person is in the country out of status, the question of whether they adjust here or process abroad, or need a waiver first, is exactly the conversation to have with an attorney before anyone books a flight.
So picture Andres again, the suit still in its garment bag in Medellin, the case approved, the interview finally within reach. Here is what changes when he and Carolina understand what they are holding. The finish line is no longer a mystery that keeps receding. It is a clear sequence. The document center first, then the embassy interview, then the visa and the flight. They know the affidavit of support is the piece most likely to stall them, so they assess Carolina's income honestly and early and line up a joint sponsor before, not after, a rejection. They know the interview screens for more than the marriage, so anything in Andreina's history is reviewed in advance, not at the window. And because Andres has been safely in Colombia the whole time, the cruelest trap, the unlawful presence bar, was never a risk for him. For families where it is a risk, they know now to ask before anyone leaves. The suit is still in the garment bag, but it is not waiting on a mystery anymore. It is waiting on a checklist, a clear one, that ends at an airport in Orlando. If you are somewhere on this same road, the most valuable thing you can do is get your own situation assessed by people who guide families through consular processing every day and who know exactly where the finish line traps are. The law offices of Chris M. Ingram has walked families through this process for more than 2 decades. Visit breakthroughusa.com to find out where you actually stand.
Before you go, one question, and keep it general in the comments. No personal details. Which surprised you more? That a fully approved case can still be refused at the embassy interview, or that leaving the country to fix a status problem can lock a person out for years? We read them, and we build episodes around the answers. Here's where we are headed next week. Andres will pass his interview and fly to Orlando, and the day he lands, he becomes a permanent resident, holding a green card at last. But that green card is the beginning of a new set of questions about keeping it, traveling on it, and one day trading it for citizenship. Next time on the Expert Guide, we start that journey. What a green card actually lets you do, the ways people accidentally put theirs at risk, and the road toward naturalization, because arriving is not the end of the story. It is the start of building a life. You have got this. We will see you next week. This has been general educational information, not legal advice. For guidance on your own situation, speak with a qualified immigration attorney.